We will have a change of panel for the next case, which is Kelly versus Kelly. Judge Monaco will be joining us. Okay.
Good morning. Please, the court. My name is Nancy Millis. I represent the appellant LAURIE Kelly. The fact that I'd like to reserve 5 minutes for rebuttal. The appellate history of this case really began on November 15, 2001. There was a hearing in front of the trial court to determine whether a lost prenuptial agreement could be reestablished. There was testimony at that hearing, and the trial court then entered an order and said, after the testimony, relying on his written notes of the testimony, he entered an order, and in that order he said, we can't reestablish this prenuptial agreement. There was no original, there was no copy, but he said it doesn't matter because Mrs. Kelly has waived all her interest in the Kelly automobile business. Ms. Kelly filed an appeal at that time. It was found to be too early. There were later appeals that were consolidated concerning the entry of the final judgment that addressed what was said at this hearing. It came up on appeal. Obviously, the alleged waiver by Mrs. Kelly affected equitable distribution, and it involved millions of dollars because the judge construed her waiver to mean she had no interest in that business. And so millions of dollars were taken out of equitable distribution and determined to be non-marital. This, on a previous appeal, the appellate court here sent it back to the trial court. And the order stated that everything was affirmed, but that the trial court had erred because it hadn't addressed issues raised with regard to the prenuptial, such as was there full financial disclosure, coercion, duress, or undue influence. Now, I filed a motion for rehearing because it didn't make sense to me exactly. How can you, if that document didn't exist, why are we doing this? But they did do it. So they went in front of the trial court, and it was determined that rather than have everyone testify over again, they would rely on the very same transcript of the November 15, 2001 hearing that had originally been held to see if the prenuptial agreement could be established. And during that hearing, which took place on March 15, 2006, opposing counsel made a statement on page 10 that I think really crystallized what happened at the previous. He was summarizing what had happened 5 years before in 2001, and he said, the former wife testified that she did not see the prenuptial agreement until the day of the wedding, and she believed that the document that she signed was 1 or 2 pages, and that the document she signed provided that she would have no interest in the former husband's business assets prior to the marriage, but any appreciation of those assets after the marriage would be a marital asset, and she would receive 1/2 of the appreciation in the event of a divorce. Now, that was what Mr. Kelly's attorney said in summarizing prior events. And we agree. Well, the judge, who is an honest, forthright individual, and looked at the transcript, said, my heavens, you know, that's not what my notes reflect. That court reporter must have been wrong, because my notes say she waived total interest, she waived all of her interest in the business. And he said, I have to get that court reporter in, because he recognized, well, my heavens, this is an obvious, serious difference. And he was shocked and appalled. Well, he did say he was going to have the court reporter in, and I don't think the record is clear about what happened after that. Now, I don't think there's any question that the court reporter was accurate, because opposing counsel, in his answer brief on page 24, acknowledges that the transcript is accurate. These things don't happen often. But in this case, the trial court judge clearly acknowledged, I relied absolutely and totally on my notes that said Ms. Kelly waived all of her interest in the business. And as a result of the trial judge's reliance on his handwritten notes, without that November 2001 hearing, when the equitable distribution was done, the wife received no interest in the appreciation of the husband's business, which, as I said, was worth millions of dollars. And then the waiver was extended to real estate. The businesses in the real estate had separate owners. Still, the ownership, Mr. Kelly obviously had an interest in it, but they were held separately. The waiver was extended to the ownership. So serious financial consequences for this mistake. What happens when there's a mistake and the trial judge obviously sees it and it's come back on remand from appeal? We would assume this doesn't happen very often. But our legal system has a remedy for this in these rare and unusual circumstances. The law of the case says generally, if a matter has been dealt with by an appellate court and the same parties and same issues are involved, you don't touch it, you leave it alone. And that certainly makes sense, because the legal system has to have some finality, and you can't be spending time re-arguing issues. But I would argue that in this case, the trial judge saw his mistake. There's case law cited in my brief that in a situation where at trial the judge says...
Okay, wait a minute. What mistake did the trial judge see?
The trial judge saw that his handwritten notes saying Mrs. Kelly waives her interest in the business were directly conflicting with the words in the transcript.
As I read the language, what it said was, if you're telling me, I think you were arguing at the time, if you're telling me that that's what the transcript said, my notes don't reflect that, I'm going to go back and look at the transcript. Thereafter, an order comes out, which essentially confirms his notes. So I guess I'm wondering, what is the mistake? I mean, presumably he's going back and looked at the transcript and decided that his notes were accurate.
Well, I think it's clear from the judge's words, he was saying that court reporter must be wrong. Because
I don't think it says that.
I think we quoted his words.
And even if it is so, what difference does it make?
If there's a direct conflict between what the judge's notes say and what's reflected in the transcript, and the opposing party acknowledges the transcript is accurate, Mrs. Kelly...
Well, it says, and I quoted that in my notes that I reviewed, now you're telling me it's not in the transcript. He's not saying anything about the transcript being wrong. What he says is that you were telling him that the transcript, that his notes were in variance with the transcript. I mean, that's different than saying the transcript's wrong.
Well, he did say he was going to get the court reporter back. I didn't argue it. Mr. Zisser argued it.
Whoever.
Yeah, it doesn't matter. I think if you read all of that colloquially, or the narrative between Mr. Zisser and the trial judge, the judge was saying, she said she's claiming half an interest in the appreciation during the marriage. That wasn't what the trial judge understood the waiver to be. Opposing counsel does not disagree that the transcript is accurate.
Is that transcript part of our record in this appeal?
I believe that it is, yes.
And can you point to a reference in that transcript which you say is inaccurate because it's inconsistent with what the trial judge's notes said?
Well, the trial judge's notes are not in the record on appeal.
Well, what does the original transcript say about what the wife testified to as to whether or not she was giving up all her interest, she was only giving up an interest in the premarital portion of it?
Well, we quoted in page 29 and 30 of our brief 4 different places in the transcript where the wife said anything that appreciated from the business after that, the marriage, was a marital asset. Page 752, any appreciation in the business from then on was a marital asset. Page 775, any appreciation or fruits of those assets during the marriage would be a marital asset. Answer, yes. So we pointed to 4 different places in the transcript where the wife said, I claim half an interest in a marital appreciation.
Well, oddly enough, one of the quote sections you quote from appears to say she's claiming 100% of what appreciated it.
Well, we didn't claim she was a wonderful mathematician, but...
Because it said if it was worth X going into the marriage and at the end of the marriage it was worth 2X, she'd get the X. So she at least apparently at one time was arguing she got all the appreciation, right?
Well, then she said I'd get half of 2X.
Half of 2X, which is X, which is all of the appreciation, right?
She wasn't a great mathematician, but...
She had a business administration degree, didn't she?
Yes, she did.
Yeah. She was a stockbroker.
Had been a stockbroker before her marriage. So clearly, the trial judge was stunned that that was Mrs. Kelly's position at trial. That was not his understanding from his notes of what she said. And opposing counsel acknowledges that the transcript is accurate. They say, well, she's not credible, or she's silly or nonsensical. Why would he do that? They're going around it and saying, no, that doesn't make sense. But clearly, it's what she said.
Well, is there contrary evidence from any source
Contrary evidence of,
what the intention of the agreement was?
I
What
wouldn't
did he-
think so, Judge, because
What did the husband testify to?
the husband testified about the agreement. He presented a document that was not signed, that had been prepared by his attorney in Philadelphia. And
This was an unsigned copy of the antenuptial agreement.
it wasn't clear if it was a first draft. It wasn't claimed that it was an exact copy because it didn't have an Exhibit A, for example.
I guess what I'm trying to get at is, did the husband testify that she wasn't to get any part of the appreciation of those assets?
I believe that was the husband's position.
Oh, well, doesn't the trial judge, who is a finder of fact, get to pick and choose among which of those pieces of testimony he wants to believe?
Well, I would suggest that if you read the order, supplemental final judgment, in there, it wasn't. What the trial judge found was, I can't reestablish that prenuptial agreement. There's not enough left. There's no evidence for me to establish a prenuptial agreement, but it doesn't matter because at trial, Ms. Kelly waived her interest in the business.
Well, he found that she waived the interest.
Yes.
Yeah, well, that's, I mean, he can do that on the basis of believing someone else other than your client.
But he didn't find that she did it based on that document that was lost. He found she did it based on that day, November 15th, 2001, that she made the waiver.
But for the judge's comments about the possible inconsistency between his notes and the transcript, that issue never would have even been reached on remand, right? The issue on remand was there coercion and was there full disclosure, correct?
That's correct.
Okay. So unless he determined that there was in fact some inconsistency that had to be rectified to avoid a manifest injustice, it's an irrelevant issue. He's really got to focus on was there full disclosure and was there duress, right?
That's what the remand said.
Okay.
And the judge, to his credit, was shocked. He said, well, that's not what my notes say. He was shocked when he was confronted with what had actually been said by Mrs. Kelly on November 15th, 2001.
You're down to about 3.5 minutes if you want to save it for everybody.
So it's our position. The judge began an investigation. He said, I want to find out. Code of Judicial Conduct says if you're going to start something, you should finish it. Nothing was ever further done on that. The remand addressed the issues of full financial disclosure. The evidence indicated that Mr. Kelly said that this missing document had full financial disclosure. There was a unsigned prenuptial agreement that referred to a Schedule A. Mr. Kelly didn't have a Schedule A. He had a memo that had,
Isn't that all argument for the trial court, though? I mean, if he said nothing but I gave her full disclosure, isn't that enough to meet his burden if the trial judge believes his testimony?
Well, there should be competent substantial evidence. He didn't have any.
His testimony's competent substantial evidence, isn't it, if the trial judge chooses to believe him?
Well, I would argue that if Mr. Kane and Mr. Elliott, the CPA and the lawyer, both said, I never prepared Exhibit A, neither one of
I
them...
said I never saw Exhibit A, or I don't remember seeing it.
Right. Neither one of them knew about Exhibit A. And Mr. Kelly, at least with the prenuptial agreement, had a draft. There was no draft of Exhibit A. How can we know if there was full financial disclosure if there's no document?
We know because the trial judge made that finding, and it was based on substantial competent evidence.
Well, there was no testimony about what it...
If you disagree with it, is a different matter altogether.
All I'm saying is, to make that finding, there was no evidence about what specifically Exhibit A included.
Yeah. We're not... Our function is not to pick and choose among the evidence.
I understand.
He made the finding, and it has substantial competent evidence substantiating it, so what are we to do with that?
With regard to the duress and the coercion, it's undisputed that the day of the wedding, a couple hours before, Mrs. Kelly was presented with a document.
But we don't have a bright line test, correct? It says if it's presented within X hours or X days of the wedding, as a matter of law, regardless of the factual circumstances, that's duress. Duress is a factual determination based on all of the circumstances for the trial judge to determine.
We certainly have guidance from the other cases where there's been less time than 2 hours. The couples were sizing their rings, and so there are certainly cases that have been reversed when there was less than 2 hours. And, the guests were gathering. It was the day of the wedding 2 hours before. Thank you.
Good morning, Your Honor. Bill Gressley from Jacksonville on behalf of the appellee. This is a simple appeal. There is no legitimate appellate issue here. Ms. Nolis is characterizing the judge's shock and recognition of a mistake when all it was her partner, Mr. Zisser, baiting the judge and saying, there's nothing in this record to support the waiver. That's absolutely inaccurate. The entire record is nothing more than a trial on the issue of whether she was believable in her version that, well, I signed a prenuptial agreement. She admitted she signed an agreement. She couldn't remember exactly what was in it, but the one thing she was clear that she had been asked to agree to months before the wedding, and she had signed, was a waiver of any interest in my client's business that he owns with his brothers. It was real estate and car dealerships that had gone back to the early 1960s. This court already affirmed the trial court's finding of waiver. What happened was the judge, because he found that the document that was presented was a draft, and just as background, my client had contended at that initial hearing on reestablishing this document that the appellant had removed it from a safe because she didn't want it to come up when they knew there was a divorce. That's not an issue, but that's how this issue of reestablishing the prenup came up. The trial on this issue, the November 15th trial, was concluded by the trial judge saying, I couldn't reestablish this particular document as the prenuptial agreement, but what's clear is the appellant has admitted that she waived her right in the husband's business assets. And in the final judgment, he likened her claim that somehow she had been tricked and hadn't really understood what she was doing as her attempt to perpetrate a fraud on the court. The order under review here is entitled Order on 2 Appellate Remands, and the judge says her claims, the appellant's claims, are not credible. She is not credible. What evidence there was to support the whole entire finding of waiver was her testimony that she admitted she had signed the document, and I have placed on page 11 through 14 of my answer brief in this appeal the testimony from my client. Again, this is the exhibit list we used with values on it, which was attached to the agreement she signed. My trial counsel asked the appellant at this trial, are you trying to tell us that you signed this agreement even though you weren't entitled to anything that was a premarital asset anyway? Well, yes. Why would the appellee have gone to the trouble of having one drafted and had 2 lawyers work on it and a CPA work on it if there was nothing that you were signing that wasn't something you were already obligated to honor anyway. I thought it was just to make his brothers happy. The judge found that not to be credible. The actual testimony was that an exhibit with full disclosure of assets was presented to the appellant in early November, weeks before the wedding. The parties had talked about a prenup and the scope of it, which was solely my client's premarital business assets with his brothers. Everything else in this case was treated as a marital asset and was equitably distributed. The appellant received over $3 million in equitable distribution. What they're talking about now is his business assets. Number one, the waiver issue is law of the case. It was already passed on by the panel that decided the initial appeal in this case. The real question presented here is, just to get it out of the way, was there some kind of mistake made that the trial judge below recognized? Absolutely not. That is a complete mischaracterization of what happened, and Your Honor's questions recognize that the trial court was baited by Mr. Zisser saying, there's nothing in here about a waiver. Well, that's absolutely not true, and I've cited in my brief the testimony. There's about 6 different places where she acknowledged that she had agreed and signed an agreement giving up her claim to the husband's business assets with his brothers. The question about the scope of that is a factual determination as well as a common sense legal interpretation. She was never entitled to a share of the premarital assets. We're talking about the appreciation. She said, I wasn't intending to give up the appreciation. Mr. Kelly testified, and my client testified, that that's exactly what they were talking about, is that she was never going to have a claim in that. So the judge picked. He finds her not credible. That is in the first final judgment under review, and it's in this one. The duress and undue influence have no factual basis whatsoever. Your Honor was correct. That is a factually driven finding. The appellant's father is a stockbroker for my client. I don't think that relation continues anymore, but that's how they met. That was in the record in the trial. She, the appellant, discussed the whole concept of a prenuptial agreement with her father. She also talked about it when she received the document. The testimony from Edward Kane, the lawyer in Philadelphia who drafted the agreement, testified that she, the appellant, called him when she received the document to talk about it and asked whether she should have her own counsel. He said, yes, you should get a counsel and review it. My client told her the same thing. This is all testimony of record. Get somebody to review it with you. The only reason that this was signed on the wedding day was because she was coming from Dallas and my client lived in Ponte Vedra. And they met in, I think it was St. Simons or Jekyll Island in South Georgia where the wedding took place. None of the facts that would support a finding of duress or undue influence are present. You're right, Your Honor, there is no bright-line test, and I agree with Ms. Nolis that the case law sort of gives us some indication. I've discussed the 2 cases that are cited, the Lutger case and the Hortus case. Neither one of those have any resemblance whatsoever to the facts of this case. The bottom line, Your Honors, is that there is no appellate issue here. This idea of a mistake is completely contrary to what the judge actually said. He did exactly what the court said. Go back and address the issues of whether there was full disclosure, whether there was undue influence or duress, which he initially said he didn't have to reach because of the waiver. The trial testimony was already there. It was legal argument by counsel pointed out exactly what the judge did. She wasn't believable. There wasn't any undue influence, and there wasn't any duress, and there was full disclosure. Those facts are supported by competent substantial evidence in the record, and affirmance, as far as I can tell, Your Honor, should be a summary thing. Thank you.
Thank you, counsel. You're down to 6 seconds, but I'll give you 30 seconds.
I would direct your attention to the transcript. The judge said, and I'm quoting on page 39, I'm very concerned about the accuracy of the court reporting because I've renewed my notes. And my notes reflect that she acknowledged she would have no part of his business. Then lower in the page, quote, the judge is saying, the client testified, the only thing I agreed to was I'd have no part of his automotive business. Now, the judge said, so as a part of the order in this case, I'm going to ask that the tapes be sequestered and submitted to the court because I want to hear them myself, because I doubt the accuracy of the court reporting for that hearing. And I want to let you all know that on the record.
Thank you, counsel. Court will be in recess.